The certified letter arrived on a Tuesday morning, stamped with the county seal and marked Final Notice of Foreclosure Sale. Daniel Crawford, 52, a third-generation cattle rancher who'd worked this land for 30 years, stood in his kitchen holding the paper with hands that had mended fences, delivered calves, and buried his father on this very property. The Henderson Hills HOA, an organization that shouldn't even exist on his ranch, was auctioning his 240 acres in 14 days. 3 months of escalating harassment, threatening letters, and legal intimidation had led to this moment. His neighbors had warned him that Patricia Hemsworth, the HOA president, destroyed anyone who challenged her authority. But what Patricia didn't know was that Daniel's great-grandfather had purchased this land in 1952, 70 years before her suburban development even existed. And inside the fireproof safe in his office sat a document that would do more than save his ranch. It would dismantle her entire empire. Before we dive into how a cattle rancher took down an entire HOA board with a single piece of paper, if you love stories where entitled people finally meet their match and justice is served, hit that like button and subscribe. Now, let's see exactly how this unfolded. This is a story in 3 parts. The violation that pushed a hardworking rancher to his breaking point, the courtroom confrontation where decades of deception unraveled, and the resolution where an entire power structure collapsed under the weight of its own arrogance. In the first part, we'll witness how Daniel Crawford endured 3 months of psychological warfare from an HOA that had no legal authority over his property. We'll see how a woman drunk on bureaucratic power used the legal system as a weapon, how she manipulated her neighbors into becoming accomplices, and how Daniel's attempts to resolve this peacefully were met with mockery and escalation. We'll feel the crushing weight of watching generations of family legacy threatened by paperwork and lies, and the moment Daniel decided that playing defense wasn't enough anymore. In the second part, we'll step inside a courtroom where Patricia Hemsworth arrived expecting a routine foreclosure approval, only to face a rancher who'd spent weeks preparing a legal counterstrike. We'll witness the moment a judge's expression changed from boredom to shock as evidence emerged, revealing not just Patricia's overreach, but a pattern of fraud that had been hiding in plain sight for years. We'll see confidence crumble and power shift in real time. In the third part, we'll discover the full scope of Patricia's scheme, watch her carefully constructed authority dissolve, and witness justice delivered not just to Daniel, but to dozens of neighbors who'd suffered in silence. We'll see how one man's refusal to surrender his family legacy triggered a legal cascade that redrew property lines, restored rights, and left an entitled tyrant facing consequences she never imagined possible. Here's exactly how it happened. Daniel Crawford had never planned to fight an HOA because his 240-acre cattle ranch had never been part of one. The property sat on the western edge of what was now called Henderson Hills, a sprawling suburban development that had grown around his family's land like a slow-moving tide over the past 15 years. Daniel's great-grandfather, William Crawford, had purchased the property in 1952 when it was still open range. Daniel's father had built the main house in 1978, and Daniel himself had taken over operations in 1995 after finishing his agricultural degree. He raised Black Angus cattle, maintained the original oak groves, and lived quietly with his wife Sarah and their 2 border collies. He was a man who preferred sunrise over paperwork, whose idea of conflict resolution was fixing fence lines with neighbors over coffee, not lawyers. That peaceful existence ended the day Patricia Hemsworth moved into the development's largest house and became HOA president. The first letter arrived in late June, a formal notice on Henderson Hills HOA letterhead stating that Daniel's failure to maintain community aesthetic standards had resulted in a fine of $500. The violations listed included unapproved fencing materials, his 70-year-old wooden post and rail fences, prohibited livestock within residential zones, his cattle on land that predated the residential zones by half a century, and failure to submit architectural plans for outbuildings. His barn, built in 1978. Daniel had laughed at first, assuming it was a mistake. He called the number listed and reached Patricia herself, explaining politely that his ranch wasn't part of the HOA, that his property had been here long before the development existed. Patricia's response was crisp and cold. According to our records, all properties within Henderson Hills boundaries fall under HOA jurisdiction. You have 30 days to comply or face additional penalties. She hung up before he could respond. The second letter arrived 3 weeks later, and the laughter died in Daniel's throat. The fine had increased to $2,000, with additional violations added: unauthorized agricultural activity, commercial operation in residential area, and refusal to cooperate with HOA authority. This letter included a threat. Continued noncompliance would result in a lien being placed on his property. Daniel drove to the county assessor's office that afternoon, pulled his property records, and confirmed what he already knew. His deed made no mention of any HOA. He drafted a careful response citing his property's history, included copies of his original deed, and sent it certified mail to the HOA's attorney. 2 days later, he received a one-sentence reply. Your objections are noted and overruled. Comply or face legal action. The breaking point came in September. Daniel returned from moving cattle to his north pasture to find a contractor's truck in his driveway and 2 men with clipboards photographing his barn. They claimed they were conducting an HOA compliance inspection authorized by the board. When Daniel ordered them off his property, they became argumentative, insisting they had legal right of access. Daniel called the sheriff's department, and the men finally left, but not before one of them said, "Lady who sent us said you'd be difficult. She was right." That evening, Daniel opened his mailbox to find the certified letter, the notice of foreclosure. Patricia had filed a lien for unpaid HOA dues and fines, totaling $18,000, a figure that included penalties, interest, and legal fees, and the county had scheduled an auction of his property for October 15th. Daniel sat in his kitchen that night, the foreclosure notice spread on the table before him, and felt something shift inside his chest. This wasn't about fences or fines anymore. This was about a woman who'd weaponized bureaucracy to steal land from families who wouldn't bow to her authority. He'd tried reason. He'd tried documentation. He'd tried following proper channels. Patricia Hemsworth had responded by attempting to take everything his family had built over 3 generations. Sarah found him in his office at midnight, surrounded by old property documents, county maps, and legal statutes. "What are you doing?" she asked. Daniel looked up, and his expression was one she'd only seen twice before, once when his father died, and once when a neighboring rancher tried to claim water rights that weren't his. "I'm done defending," he said quietly. "Time to go on a fence." The courtroom was smaller than Daniel expected, with fluorescent lights that hummed and wooden benches that creaked. Judge Margaret Thornton presided over the foreclosure docket every Tuesday morning, a routine assembly line of mortgage defaults and tax sales. Patricia Hemsworth sat in the front row, perfectly composed in a cream blazer and pearls, flanked by her HOA attorney Marcus Webb and 2 board members who served as witnesses. She'd attended 3 foreclosure approvals before this one, watching properties transfer ownership with bureaucratic efficiency. Today would be no different, just another non-compliant property owner learning that HOA authority superseded individual stubbornness. She'd already arranged for a developer friend to purchase the Crawford Ranch at auction, splitting the profits 60-40. Patricia didn't even glance at Daniel when he entered with his attorney, a sharp-eyed woman named Rebecca Torres who specialized in property law. Judge Thornton called the case at 10:17 a.m. Henderson Hills Homeowners Association versus Daniel Crawford, foreclosure proceeding for unpaid dues and fines. Marcus Webb stood, presenting the standard petition. Valid lien, proper notice, legal authority under HOA covenants, request for foreclosure approval. His presentation lasted 4 minutes and was delivered with the bored confidence of a man who'd done this 100 times. Judge Thornton looked ready to approve with a signature when Rebecca Torres stood. "Your Honor, before you rule, the defendant wishes to present evidence that fundamentally challenges the plaintiff's claim of authority." The judge paused, pen hovering. "This is a foreclosure proceeding, counselor. The time for dispute was before the lien was filed." Rebecca's response was calm but firm. "Your Honor, the evidence will show that the plaintiff's lien is fraudulent. because the plaintiff has no legal jurisdiction over the defendant's property whatsoever. The temperature in the courtroom shifted. Judge Thornton set down her pen. That's a serious allegation. What evidence? Rebecca nodded to Daniel, who approached with a leather document folder. He placed papers on the judge's bench while Rebecca spoke. The Crawford Ranch was purchased by William Crawford in 1952 via warranty deed from the Larson family, who'd owned the land since 1923. The property has been continuously held by the Crawford family for 71 years. The Henderson Hills development was constructed beginning in 2007, 55 years after the Crawford purchase. She laid out a series of documents. The original 1952 deed, property tax records showing continuous Crawford ownership, and a modern survey. The development's plat map, filed in 2006, shows the Crawford property clearly marked as existing private parcel, not included in subdivision. Your Honor, the HOA's claim of authority requires that Mr. Crawford's property was either part of the original subdivision or that he voluntarily joined the HOA. Neither is true. Patricia's composure cracked. She leaned toward Marcus Webb, whispering urgently. The attorney's face had gone pale. Judge Thornton was studying the documents with increasing intensity. Mr. Webb, did your client verify jurisdiction before filing this lien? Webb stood unsteadily. Your Honor, the HOA's records indicate— I didn't ask about records, the judge interrupted. I asked if you verified actual legal authority. The silence stretched. Rebecca pressed forward. Your Honor, we have evidence that Ms. Hemsworth knew the Crawford property was exempt. This email, sent from her personal account to the HOA attorney last May, explicitly states, I don't care what the old deeds say. If they're surrounded by our development, they're part of our jurisdiction. File the lien and we'll force compliance through financial pressure. The courtroom erupted. Patricia shot to her feet. That's privileged communication. Where did you get that? Daniel spoke for the first time, his voice carrying the quiet authority of a man who'd found his footing. Your attorney's paralegal is married to my nephew. She saw what you were doing to families in this community and decided someone needed to stop you. He turned to face Patricia directly. You've done this before, haven't you? Targeted properties on the edges of the development, filed fraudulent liens, forced people to pay or lose everything. Rebecca added another document to the pile. Your Honor, we've identified 6 other properties in the past 3 years where the HOA filed liens against homeowners whose properties weren't actually subject to HOA authority. 3 families paid under duress. 2 lost their homes to foreclosure. 1 is still fighting. Judge Thornton's expression had transformed from bureaucratic efficiency to focused anger. She looked at Marcus Webb. Did you know about any of this? The attorney was already gathering his papers. Your Honor, I'm going to need to consult with my client and withdraw from this case. You'll stay right where you are, the judge snapped. She turned to Patricia. Ms. Hemsworth, you filed a lien claiming $18,000 in dues and fines against a property that was never subject to your authority, knowing that the threat of foreclosure would pressure compliance. Is that accurate? Patricia's pearls caught the fluorescent light as she struggled for composure. The HOA board voted to expand our jurisdiction to include all properties within our geographic boundaries. We have that authority. No, Judge Thornton said flatly, you don't. And this court is going to ensure you never attempt this fraud again. The judge's next words fell like a gavel strike. The lien is declared invalid and will be removed from county records immediately. Mr. Crawford, you owe nothing. Furthermore, I'm ordering a full investigation into every lien filed by this HOA in the past 5 years. She looked at Patricia with undisguised contempt. Ms. Hemsworth, you attempted to use this court as an instrument of theft. You will face consequences. Patricia opened her mouth to protest, but no words came. For the first time in her tenure as HOA president, she had no authority, no leverage, no power. Daniel watched her face cycle through disbelief, rage, and finally fear. He thought about saying something, delivering a triumphant speech about family legacy and justice. Instead, he simply nodded to Rebecca and walked out of the courtroom, leaving Patricia to face the legal storm she'd created. The foreclosure hearing ended at 11:43 a.m. By 2:00 p.m. that same afternoon, news had spread through Henderson Hills like wildfire through dry grass. The investigation Judge Thornton ordered moved with surprising speed, partly because the evidence was documented in the HOA's own records, and partly because once people knew Patricia could be challenged, victims came forward in numbers. By the end of the first week, county investigators had identified 11 properties where the HOA had filed questionable liens. 8 of those properties, including Daniel's, had never been part of the original subdivision. 3 were in the development but had been targeted with inflated fines for violations that didn't exist in the actual HOA covenants. The families who'd lost homes to foreclosure filed suit for fraud. The families who'd paid under duress demanded refunds. And the current residents who'd been living under Patricia's arbitrary rule began asking questions about where their dues had actually been going. Daniel spent that first week answering calls from neighbors he'd never met, people from inside the development who'd been fined for everything from unapproved mailbox colors to excessive yard decorations. One woman had been fined $800 for a small vegetable garden. Each story followed the same pattern. Patricia would identify something she personally disliked, declare it a violation, and threaten financial ruin if residents didn't comply. One retired veteran had been fined for flying an American flag deemed too large. A schoolteacher had been fined for parking her 10-year-old car in her driveway instead of her garage. A young couple with twins had been fined for leaving a stroller on their front porch. The fines were always high enough to hurt, but low enough that most people just paid rather than fight. Patricia had built a kingdom on intimidation and bureaucratic language, counting on people's fear of legal systems to keep them compliant. The second HOA board meeting after the hearing was standing room only. Patricia arrived 15 minutes late, flanked by her attorney, a new one since Marcus Webb had withdrawn from all HOA representation and tried to call the meeting to order. The residents weren't having it. Tom Brennan, a construction foreman who'd been fined twice for unauthorized vehicle parking, his work truck, took the floor and refused to yield it. He read aloud from the HOA's original covenants, highlighting sections that Patricia had ignored or rewritten to suit her preferences. Another resident presented a spreadsheet showing that Patricia had spent $43,000 of HOA funds on legal fees. In the past year alone, most of it directed at residents within the community. When Patricia tried to dismiss these concerns as administrative matters outside residents' authority, Janet Kowalski, a lawyer who lived 3 streets over, stood and explained precisely why every action Patricia had taken in the past 2 years could be challenged as exceeding her authority. The board members who'd supported Patricia, the ones who'd sat silent while she targeted their neighbors, suddenly found reasons to resign. By the meeting's end, Patricia was alone at the head table, facing 200 angry residents and no allies. The formal dissolution of Patricia's authority came through multiple channels. The county attorney's office filed charges for fraud and attempted theft. The civil suits from foreclosed families moved forward, with Daniel serving as a witness in 3 separate cases. The HOA itself held a special election, removing Patricia as president by a vote of 286 to 3, the 3 being Patricia herself and 2 friends who didn't live in the development. The new board, led by Tom Brennan and Janet Kowalski, immediately voted to rescind every fine issued under Patricia's presidency, pending individual review. They discovered that Patricia had amended the HOA covenants 16 times without proper resident approval, each amendment expanding her authority or creating new fine categories. The board voided all 16 amendments, reverting to the original 2007 covenants, which were surprisingly reasonable and focused on genuine community concerns rather than aesthetic dictatorship. For Daniel, the resolution came in stages. The fraudulent lien was removed from his property records within 72 hours of the hearing. The HOA issued a formal apology, delivered personally by Tom Brennan, who'd walked to the ranch with a handwritten letter signed by 47 residents. The county cleared Patricia's frivolous violations from Daniel's record and issued a formal statement confirming that his ranch had never been subject to HOA authority. But the real resolution came 6 weeks after the hearing, when Daniel stood in his north pasture at sunrise, watching his cattle graze against a backdrop of oak trees his great-grandfather had refused to cut. Sarah joined him, carrying 2 mugs of coffee, and they stood together in the quiet morning. "You saved more than just our land," she said. Daniel nodded. wasn't just about us anymore. People needed to know they could fight back. 2 months after the confrontation, Patricia Hemsworth's house went on the market. The civil suits had drained her savings, and the criminal charges, ultimately reduced to misdemeanor fraud with probation and restitution, had destroyed her reputation. She moved to another state, though rumors suggested she'd tried joining a condo board there and been rejected once residents learned her history. The Henderson Hills HOA continued under new leadership, focused on actual community needs, maintaining common areas, organizing neighborhood events, keeping streets plowed in winter. Fines were rare and reasonable. Threats were non-existent. And on the western edge of the development, the Crawford Ranch continued its quiet work, 3 generations of family legacy intact and protected, a testament to what happens when someone mistakes fear for respect and authority for righteousness. Daniel learned later that 4 other property owners in similar situations across the county had used his case as precedent to challenge HOA overreach. 2 won outright. 1 settled favorably. 1 was still fighting but had new ammunition. He thought about his great-grandfather sometimes, William Crawford, who'd bought this land with savings from working railroad construction, who'd built the first fence lines with his own hands. William had never faced an HOA board, but he'd faced drought, market crashes, and neighbors who'd thought a railroad worker had no business owning ranch land. He'd fought for what was his and built something worth protecting. Standing in his kitchen on a December morning, the foreclosure notice now framed on the wall as a reminder, Daniel understood that some fights weren't just about winning. They were about showing others that winning was possible. Patricia Hemsworth had wielded paperwork and legal threats like weapons, counting on people's exhaustion and fear to build her power. She'd forgotten that paper authority only works when people accept it. And when someone finally stands up with the truth, that paper authority burns like kindling. Daniel had learned that sometimes justice doesn't come from avoiding conflict. Sometimes it comes from meeting entitled tyranny with documentation, patience, and the stubborn refusal to let bullies win. And as he looked out over his land, acres his family had worked for 71 years and would work for 71 more, he smiled. Because justice, whether delivered in a courtroom or across a kitchen table covered in old deeds, was always worth the fight. Across the country in Portland, Oregon, Margaret Chen, a 61-year-old retired civil engineer who designed bridges for 30 years, received a letter from her new HOA board demanding she remove the wheelchair ramp on her front porch. Margaret, who'd been using a wheelchair since a car accident 3 years ago, read the letter twice, then pulled out her laptop and began typing. What the board president didn't know was that Margaret had spent her career studying the Americans with Disabilities Act and had personally trained municipal inspectors on accessibility compliance. She smiled, the same smile that once preceded her dismantling of unsafe building proposals, and began drafting a response that would include federal law citations, state regulations, and a personal invitation for the board president to explain their position to her attorney, who happened to be a disability rights specialist. "By all means," she murmured, "let's discuss reasonable accommodation." The board president would regret that letter within 48 hours, but that's a story for another time.